The Trump administration is racking up their losses in court. In the latest, a Bush-appointed federal judge has ordered the Department of Health and Human Services, CDC, and FDA to reinstate the web pages that they took down because of Trump's executive order having to do with gender ideology. My name is Dina Doll with the Legal AF channel. Let's break this all down. So one of the many orders that Trump did with his executive order was trying to do away with, as he says, gender woke ideology. And what then happened was these agencies took down vast amount of medical information essentially on their pages, medical information that the doctors use, that the doctors use for things like treatment, for clinical trials. There was data out there. It was results of the clinical trials. It was guidance for how to treat public health issues. And so the doctors sued, saying, now that, you taking down this information is harming our patients because we need access to that information. And they filed a lawsuit in federal court saying just this. Let me read from you from the complaint so you can get a sense of exactly what they said. But it was essentially saying that this information is essential in order for us to provide treatment. So is the Doctors for America suing the Office of Personnel Management, which is the one that sent out this memo saying we need to do this in order to comply with Trump's executive order on gender ideology. And so the doctors went in court and they said that you removing this information from your websites is a violation of the Administrative Procedures Act. Now, you've heard that a few times. That is an act that governs how agencies are supposed to function. One of the ways they're supposed to function is not in arbitrary or capricious ways, and that came in with this lawsuit as well. In addition, the Paperwork Reduction Act. So they said that them taking this down as they did was a violation of both of those acts, and that they're asking the judge for this immediate order, the temporary restraining order, because they're saying if you do not rule now, we will be irreparably harmed by not having this information. Because as we know, the standards for a motion for restraining order are how likely are you to succeed on the merits, and how will your harm kind of not be able to be undone. And the doctor's arguing here that this patient that we cannot treat because we don't have accurate information, that harm is irreparable. Like if you go on and in a few months, or years, frankly, once this litigation goes through and put up that information, that patient's harm cannot be undone. And so that's, why they're arguing that they qualify for this motion for a temporary restraining order. So what they specifically say is that they're saying that the Paperwork Reduction Act, quote, requires every federal agency to ensure that the public has timely and equitable access to the agency's public information. It also requires agencies to provide adequate notice when initiating, substantially modifying, or terminating significant information dissemination products, which the HHS and other agencies define to include any electronic document or web page that an agency has disseminated to the public. So clearly here, them not providing any adequate notice as they take these pages down immediately after this order. So the Doctors for America are arguing that this kind of like political gamemanship with taking down information to the public and to doctors specifically is harming patients, harming Americans. And this is what they say specifically. It says that DFA, that Doctors for America, further contends that its members are and will continue to be irreparably harmed by the lack of access to the removed web pages because DFA members regularly rely on the removed web pages to provide timely patient treatment, inform public health responses, and conduct health-related research. Specifically, the lack of access has made it more difficult and time-consuming to provide updated recommendations and prescribe appropriate options to patients. And alternate resources may not be as comprehensive, up-to-date, relevant, and accessible to DFA's healthcare providers as the removed web pages. I mean, these are doctors saying, we need this to take care of our patients. People's health is at risk. You're playing games by taking this information down. And the judge agreeing with them. The judge really agreeing on all points, agreeing with the likelihood that they will be win on the merits, the fact that this is arbitrary and capricious, and that it needs this order now, right? The imminent, irreparable damage. And so the judge finding specifically for them and saying that the court agrees that DFA has demonstrated a likelihood of success on the merits as to this claim by removing long relied upon medical resources without explanation. It is likely that the agency failed to examine the relevant data and articulate a satisfactory explanation for its action, including a rational connection between the facts found and the choice made. I mean, this is the definition of arbitrary. They just have this idea of like taking out woke language, as they said, and you're completely taking out pages and pages of important information, and the judge really agreeing with them there. And the judge going on to say, hand in hand with the lack of explanation, it is also likely that the agencies fail to consider the important issue of the substantial reliance by medical professionals on the removed web pages. The court agreeing here how important it is for the doctors to be able to rely on this, and really the agencies not taking that into consideration when they took it down. So the court goes on to say, DFA has thus shown a substantial likelihood of success on the merits as to its claims that CDC, HHS, and FDA acted arbitrary and capriciously in removing the web pages, agreeing also with the irreparable harm, because you're dealing with, patients that are sick. If you don't get them, if they cannot get the treatment, that is a harm that cannot be remedied if we are waiting for this to move on. And the court really ending its finding with something that, again, this is a Bush-appointed judge at finding how something that seems so logical, so reasonable, but of course, in this day and age, this is some progressive or activist. But remember, this is a Bush-appointed judge. It shows how far Trump and MAGA have come, even honestly, from conservative Republican policies. The judge ends with, quote, finally, it bears emphasizing who ultimately bears the harm of defendants' actions. Everyday Americans, and most acutely, underprivileged Americans seeking health care. That statement from a Bush-appointed judge really revealing how little Trump's actions have to do with benefiting everyday Americans, everyday working Americans, people who need their doctors to be informed so they can get health care. Instead, he's playing politics with language and words and taking down this information. We saw him doing something similar with putting out an order that somehow with the FAA, they have to address pilots instead of air mission as airmen. Seemingly they're okay with calling female pilots men. I mean, there's like an obsession with language on their part. And here in particular, that obsession with language harming in real time patients who need the information. So this judge giving yet another loss to the Trump administration.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.